So we're going to go to our first segment here, which is with our interview with Deputy Public Safety Inspector General Deborah Witzburg. It's an office I played a big role in helping create, and basically they audit the police department. This one in particular is a review analysis of the grievance process. It's a really, really important thing. It's been a hidden way and remains a hidden way now about how the police department and police officers skate responsibility and oftentimes have their records kind of expunged and erased. It's really a fascinating discussion. It runs about 28 minutes. I'll come back and talk about it a little bit, and then we'll get on to our other segments. So hopefully I will see you on the other end. Enjoy the interview with Deborah, and we'll be back in a little bit. Deborah Witzburg, thank you so much for joining us. We really appreciate you jumping back on the show.
Thank you. Thanks for having me.
All right, so I want to get the title right. We're going to talk about a recent report you guys dropped, a review of the disciplinary grievance procedure for Chicago Police Department members. Now, before we get into the findings, and the report is amazing, I really love all the work you guys are doing. I'm so glad I was part of actually making this office happen. I was told years ago by a source in IPRA, a very high source in IPRA, that the grievance process was so screwed up that the city, most of the time, when an officer grieved his or her discipline, they would most of the time cave automatically rather than even go through arbitration because they didn't want to spend money knowing they'd lose. So we got told that 15 years ago, and we've been trying to get, we tried to get IPRA, we tried to talk to when they set up COPRA to force them to make data about this available. Obviously, they wanted no part of it. All right, so that's the back end of my story about grievance process. So can you explain to people, our audience, what is the grievance process?
Yes, I can. Although, as you point out, the grievance procedure is part of this incredibly procedurally complex disciplinary system, which really threatens to collapse under its own weight in terms of complexity. And I think it's really important to understand this specific piece of the process that we're going to talk about today against that larger backdrop, and against the backdrop of how little meaningful transparency there is into the police disciplinary system. So with all of that in mind, the disciplinary grievance procedure is the set of mechanisms by which members of the Chicago Police Department can challenge certain kinds of discipline which has been recommended for them. So in this Byzantine process, we have investigating agencies, primarily the Bureau of Internal Affairs and COPA, which conduct disciplinary investigations. They reach investigative findings, and where they have sustained disciplinary allegations, they recommend discipline. Depending on the amount and type of discipline recommended and the rank and position of the CPD member who is being disciplined, there are different options available to that member to challenge, or sort of like an appeal to challenge the recommended discipline. And so some of those challenges, some of those avenues to challenge fall under the sort of grievance procedure available to sworn members of the police department represented by the major units. And that is the Fraternal Order of Police, representing police officers, everybody below the rank of sergeant. And then the PVPA, which has different units representing supervisors, sergeants, captains, and lieutenants. And so we undertook in this project to look at the way the grievance process works and what its outcomes look like, both in terms of substantive outcomes for discipline of Chicago Police Department members who have been found to commit misconduct, have committed misconduct, but also what it looks like from a public transparency perspective.
Okay, and it's not transparent at all. As someone who's followed this since 1995, I can tell you it's not transparent at all. And if and when we used to meet with internal affairs every 6 months, the head of internal affairs used to meet the head of IPRA for every 6 months. And even the answers we would get from them always varied. IPRA was supposed to be notified of the findings in the end of the grievance process, but often wasn't. They didn't know things happened. They didn't know sentences were reduced. So we'll get to all of that. What data did you all look at in this process, and how, in what time frame?
We looked at disciplinary cases which were grieved in one of these grievance procedure pathways between the end of 2014 and the end of 2017.
Okay, so let's start with, let our audience know. So this process, if it gets to an arbitration, if there's an arbitrator overseeing this process, which from my understanding is just some kind of private lawyer that acts as a judge, more or less acts as a judge in negotiating or finding a resolution to this dispute. How is that person picked, and how many arbitrators have been used over this time period? Because that seems to be an important piece of this.
So that's right. So arbitration is one of these grievance pathways. And you're right, there's an attorney who acts as an arbitrator, who's sort of a finder of fact, an adjudicator. Our formal arbitrations involve an evidentiary hearing and then a written opinion by an arbitrator. A couple things to be said about those arbitrators. So to answer your question, the arbitrator is selected by mutual agreement of the parties, so the city and the CPD member, right? From a quote unquote working list of approved arbitrators. There are no formalized criteria for selection of those people. There are no criteria for removal of those people from the formalized list. An exceptionally high percentage of arbitrations, which is to say 90% of grievance arbitrations between the end of 2014 and the end of 2017 were assigned to 3 arbitrators. So 3 people decided 90% of the grievance arbitrations in a 3-year period.
Right, and this is very important because they have to be mutually decided upon, right? So if these people hand down a decision that is in the eyes of either party, the union more or less, or the CPD, too far in a direction, they may not get more business. They may not get selected.
I think that's a reasonable read of the absence of criteria for either selection or removal. The other, I think, really important thing to keep in mind about these arbitrators is that they are, by virtue of this sort of structure of the system here, they are endowed with a huge amount of authority and discretion. So when an arbitration comes to them for adjudicating, for a decision, they have very broad authority in terms of what they want to look at. And what that often amounts to is basically new fact finding. So by the time something comes before an arbitrator, there has been an investigation by one of the investigative bodies, and that body has come to investigative findings and a recommendation. The arbitrator is not bound in any way by the findings or the recommendations of the investigative agency, which is to say they can, in a way that is marked by pretty unfettered discretion, engage in totally new fact finding and a totally new sort of decision-making process. Their decisions then, once an arbitrator has made a decision, those decisions are subject only to very, very limited appeal to the circuit court. And the circuit court is bound to give a great deal of deference to an arbitrator's decision. And so we have this sort of asymmetry where the arbitrator is not bound at all to give any deference to the findings of fact or the recommendations made by the entity with the closest to the ground access to the information. And once the arbitrator makes that decision, there are only very, very limited grounds on which it can be overturned.
Yeah, that sounds like an excellent system, right? Add that up, and with no transparency about what's going on, seems pretty scary to me. Okay, let's
agreed. And I think, sorry to interrupt, the recommendations in this report really come from 2 angles here. One is to improve the way this process works, right? There's sort of a basic procedural fairness concern about a system in which 3 people who are not particularly subject to public scrutiny decide 90% of the cases. So, substantive improvements to the system, but also improving the transparency into it. This whole system largely operates outside of public view. And I think, what you can see from the police department to some extent, and certainly from the law department's responses to our recommendations, is that lack of public transparency is not accidental, it's strategic. So in response to a number of our recommendations, the city articulated the view that it would compromise their litigative strategy to provide more transparency into the system. Where we are in a world where the city of Chicago's law department explicitly articulates a view of this problem that kind of, values litigative strategy over public transparency, I think that explains a lot of where we are with the police disciplinary system.
Right, and they simply don't want people to know how badly the process works. That's what that's about. Litigation strategy, if they have one, that cracks me up. I mean, for better or worse, whether you like Mayor Lightfoot's tenure, she did call out just how bad the Department of Labor, this same piece of the law department, presents case to the police board when she was head of the police board. She told them, start hiring outside counsel. Your lawyers are horrible. They're putting on horrible cases. But to her credit, that was all done in public. And the police board's reasonably transparent and incredibly transparent to this process compared to this process. God, this is scary. I wonder, what if we looked on, well, we're sending a bunch of FOIAs in based on this. It's time this process gets open, but I can just imagine how scary these numbers are long-term if you looked at 20 years. Okay, let's check a couple of the findings here. 78% of cases resulted in discipline being reduced or eliminated. That's a mind-boggling number. That is just over 3 out of every 4 cases where the discipline recommendation is reduced.
So it is a staggeringly high number. It's, I think, important to understand, to consider it in context, right? So
yep.
78% of cases, one way of looking at that number would be to say that, you would expect people to grieve cases where there is some sort of vulnerability in the finding. And so why would people grieve a case if there wasn't some reason that that the discipline would be reduced or eliminated? We need to understand that number in the context of what else we know about how the system is working. So in a system where there's a fair amount of control over who is deciding these cases, as we talked about, and what the outcomes might be, it's easy to imagine a world in which people sort of grieve discipline as a matter of course, not because of some specific concern about the actual content of the investigation, but because in the substantial majority of the time, the discipline is reduced or eliminated.
Right, and that's what we heard, which was they grieve everything. And the city is so used to losing those in arbitration, they just come to some settlement agreement as a matter of course and just reduce it somewhat, 50%, 70%.
We looked at the settlement process as well, and settlements are frankly poorly controlled as a matter of policy. A settlement can happen at a variety of stages in this sort of investigative and disciplinary process, and it can have a range of outcomes. What we found often is the case when we looked at settlements is that they result in the elimination entirely of certain rule violations from a disciplinary record. So Chicago Police Department members are disciplined, generally speaking, for violating the rules and regulations of the Chicago Police Department. Not all rules, not all regulations, not all policies are created equal. What we found when we looked at settlements is that some very serious rule violations about which we should all be very concerned were very frequently removed entirely from a disciplinary record when the case was subject to a settlement. So for example, Rule 14 of the Chicago Department's Rules and Regulations prohibits the making of false reports. This is sort of at the very center of policing and criminal prosecution, right? Really important to think about CPD. I know you and I have talked about this before. The Chicago Police Department is part of the sort of criminal justice ecosystem. And when we think about the sort of paroxysm of violent crime with which Chicago is currently faced, we need to be thinking about effective policing in the context of fair and effective criminal prosecution in a way that is actually tailored to keep people safe. So all of that is to say, the ability to testify in court in criminal prosecutions is a vital part of a police officer's job. If a police officer has been found to have lied, told a lie, then their ability to testify in court is forever afterwards compromised. And defendants in criminal proceedings have a constitutional right to that information. What we found when we looked at settlements, disciplinary grievance settlements, is that in our sample, there were 21 cases that were subject to a settlement process where there was a Rule 14 violation that had been sustained. That is to say, an investigating agency, either BIA or COPA, reached findings that a member of the Chicago Police Department had lied. And in all 21 of those cases in our sample where there was a sustained Rule 14 violation, that violation was removed from the record in the course of the settlement proceeding. And therefore, for all 21 of those CPD members, despite the fact that an investigating agency had found that they had violated Rule 14, that violation is not part of their disciplinary history.
That is mind-blowingly horrible because it's like erasing, their history. I didn't know that they were doing that. That to me is very, very serious. No wonder they go through grievance process so much. That's fascinating. I wonder, were you able, I'm sure you weren't, but I'm going to ask anyways, like any semblance of why they were doing that?
Well, one of the recommendations we made around the settlement process, many of which were geared toward this sort of transparency question, how much view the public has into how these processes work and what their outcomes are. One of the recommendations we made was that in any settlement agreement, which entails the removal of certain rule violations, that the document, the record of that agreement include an explanation for why those rule violations were removed. That is one of the recommendations in response to which the city offered that it would not follow that recommendation because doing so would compromise attorney-client privilege and its sort of legal strategy.
Attorney-client privilege. Yeah, that one's a loss on me, but like half their excuses. And we're going to talk about one right now. We're going to talk quickly about a couple of recommendations. So one of your recommendations, obviously open this up and be transparent about what's going on, right? Not a hard thing to understand in 2021, they disagreed and said they lacked resources. Now, before I get you to comment, I want to tell you a quick story. We used to meet with the head of internal affairs when I was part of the Chicago Coalition for Police Accountability and the head of IPRA every 6 months or so in the Corporation Council. We were in a boardroom at the Cook County Public Defender's office. There's like 25 people around this big table. And on the opposite end of the table is the head of internal affairs and the general counsel. And my colleague, who's since passed recently, unfortunately, Harold, asked, so why doesn't the internal affairs have a dashboard or a website? Why don't they release data every quarter like IPRA does? And their response then, this was probably 2015 or so, their response was, we can't find the appropriate website to do that. And he's since retired now, but Commander Jonathan Lewin, who was like their technology guy, was sitting right next to me. And we know each other. He was on my radio show years ago. He put his face in his hands and tried to like disappear out of the room. I could feel him like hoping that no one would turn to him and ask him how the police department that's won awards for their like clear map website could not have an appropriate website to do it. We didn't ask him, but anyways, that's just how untransparent they've wanted to be. So what did the police department and the Department of Law say to open this process up to transparency?
So there are some specifics, but I think broadly, there were sort of two categories of responses where the law department and the police department declined our transparency recommendations. And those responses, such that they have to do with, as you say, a lack of resources. And there are a couple of places in which the law department said they don't have the data. They don't themselves have access to the data, which they would need to provide to the public in order to meet our recommendations. I'll say a couple things about both of those categories. I am myself, as I think many others are, running short on patience with the notion that the lack of transparency into the police department and the police disciplinary system is a resource problem. The city of Chicago is paying tens of millions of dollars a year to settle misconduct lawsuits and to pay judgments. if we were serious about this being a resource problem, we would be taking measures to reduce the problems which lead to those situations. That's what I would say about resources. With respect to access to data, if the law department representing the city of Chicago does not itself have access to the data which would be required for public transparency, I can imagine no stronger argument for the need for improved data collection, data quality, and data access. So where this is the same administration which posed challenges to an ordinance before the city council recently, which would have allowed our office to greatly increase the amount of data about police disciplinary histories, which is readily and publicly available, perhaps they themselves could make use of that sort of resource.
Yeah, they just don't want it. I mean, that's the bottom line. I will tell you that we have this ordinance that we got introduced last under Rom, and now we're going to be pushing it soon again. We're adjusting it to include the grievance process data on transparency, but it's called the Police Settlement Transparency and Accountability Ordinance. And it's basically to open up data around litigation involving civil settlements and judgments against the police department for anything, but mostly for misconduct. And you know, I've had some national level experts looked at it, gave us input into it, but I've had some local people, supposedly in the police reform field, area, and they were talking about, well, that's way too much work for the Department of Law to keep track of who is working on what case and how much time they spend on it. And if they shop it out to a private firm, how are they going to keep track? That's way too much. And wait a minute. That's what private lawyers do. Whether like I have a friend who's a high level consultant in DC here. She bills out her time in 6-minute increments. She keeps track of her time in 6-minute increments. The Department of Law can do it. Now, I'm not saying go back over the last 40 years and go through all the cases and figure it out. I'm not that stupid. But going forward, if you tell them to keep track of it, they should be able to do it. But to some degree, this is a lack. In my opinion, it's all a lack of will.
I agree. It is a lack of will. And I think that, one way to read these responses is sort of to hear the city saying, we're not going to make this information available or publicly transparent. Trust us. And I think the place at which we find ourselves is that the city hasn't earned that trust, hasn't earned public confidence. And so what the city of Chicago owes to members of the public, and not for nothing, members of the police department, is meaningful transparency into how this system works.
Right. As I say, the union, and you take the Laquan McDonald case, for example, their extremist view of representing to the loudest they possibly can any cop who does anything wrong, full on bore, no matter how bad it is, it hurts. The people it hurts the most besides the public is their actual other members of their union, right? In the Laquan McDonald case, they were doing everything right until Jason Van Dyke got out of it, pulled up on the scene, didn't know what was going, got out of his car and shot. And then he put those other 10 officers on the block about what they were going to do. Risk going against the blue wall of silence or risk your career. And I view this the same way with the litigation and the police accountability system. The distrust from the public in the police accountability system is equal, if not worse. It's equaled or it's even worse when the police department, because the police officers themselves don't trust the disciplinary system. But if things were more public and people understood what they were actually getting in trouble for rather than the rumor mill, that would probably put more faith in the system. And if the system sucks and they're doing things arbitrarily or there is corruption, then let's out it and get rid of it so that the police can have faith in it.
That it is absolutely the case in my view that all Chicagoans, in uniform and out, are entitled to a police disciplinary system which is transparent and robust and reliable. And that's something that at the moment nobody has. And in part that goes back to sort of where we started, which is the overwhelming procedural complexity of the system. Mm-hmm. So one of the things that we've worked on recently, and maybe you've seen this, it's now up on our website, is sort of a comprehensive process map of the disciplinary system. And it's sort of interactive, and you can work your way through this process map by department member rank and investigating agency and so on. And we've sort of mapped out all of the tributaries of this system. It is astonishingly complicated.
It is, and there's no doubt about it. And very few people understand how the system works. And unfortunately, even crime reporters, we should not have crime reporters, we should have police reporters, but the crime reporters most of the time still don't understand how it necessarily all works. And I've never seen an article, the media falling down on the job, where has been the articles about what's going on in the grievance process, right? The first thing I've ever seen published on it is this report, which is, I mean, great report, but it's sad that it had to come to 2021. All right, one other recommendation that I want to talk about, ladies and gentlemen, you should go to the website. The link will be up on our site. It's an astonishing thing to read. We could have probably talked 3 hours about it. So I'm going to read I think it's finding 3. The settlement process, which regularly results in significant reductions in discipline and the removal of rule violations from sworn members' records, lacks transparency and fails to produce consistent settlement agreements that follow a consistent format. That last part is what I want to get to, because that reminds me of the police board. Depending on who was writing up the charges when the superintendent was filing them and who was writing up the decisions, the format on those things swing dramatically. And for someone who's trying to take that data and put it into a database for our police board website, cpdinfocenter.org, by the way, it is always annoyed the crap out of me that is inconsistent. So this basically same thing is happening in the decisions for the arbitration process.
We're speaking specifically to settlement agreements there, but
Okay.
yes, that's the idea. And I think, important to be clear that when we talk about a consistent format, we're not talking about like font and spacing, right? The notion is just that there needs to be some consistency across cases in what information is included in those agreements, what you might learn from reading them, right? And how much, again, transparency into the process those agreements should provide. So that's the sort of consistency that we're trying to get out there.
Right, but when you're trying to hide and cover up things and make sure reporters don't get them and I don't get them, then you purposely keep it as vague as possible so that you can't hold anyone accountable. I mean, it's the Chicago way of doing things.
Well, we certainly did not find evidence that anybody was intentionally covering things up, although the impact of this system is clearly one in which there is not enough information available to the public. That's right.
Right, and if in my view, if that information to the public helped the city or helped the police department, it would be public, right? I am a firm believer where there's smoke, there's fire, especially in Chicago, especially around police accountability. Things are done for a way because it helps keep the system churning, or it helps keep things away from the public. It is not an accident. That's my view only.
Well, I think, to go back to an earlier comment, the city has not earned the benefit of the doubt that would prevent people from thinking that.
Oh no, exactly. This is the problem. This is that's entirely the problem, and we just keep doing it over and over. They think, well, we've earned the trust. Trust us. What? No, you covered up the Laquan McDonald tape for how long, right? And we can go after case after case after case. Anyways. You should go to the website and read it, ladies and gentlemen. It's a fascinating report. You can also see Deborah's on YouTube or on Facebook. You can see she's appeared 4 times maybe on this show. They keep pumping out great research, and hopefully this has an impact. CJP is going to be attacking this arbitration process, grievance process, and look out soon, I would say by August, for a new slew of lawsuits against, now we're looking at 5 agencies in Chicago related to police accountability and transparency things. Deborah, thanks so much for being here. Really appreciate it. Stay safe.
Thank you. Thanks for having me. See you soon.
All right, we are back. Once again, I want to thank Deborah Witzburg. She's been on the show 4 times. She's obviously great. The report's fascinating. And once again, to just reiterate, if the point wasn't made long enough or strong enough, when you see these systems like this grievance system buried so far, so deep that no one knows what's going on, and it's almost impossible to figure out what's going on, that's for a reason, right? It helps the police department, it helps their officers, it helps the mayor's office and the city council avoid responsibility for creating such a horrible system. It helps the union. They all benefit from the crappy system that there is. Otherwise, it would be changed, right? If it wasn't serving their needs, things would be changed. Especially with the police department, they would do something to change the system if it actually wasn't benefiting them or their officers. So the system isn't set up that way by accident. It is absolutely purposeful. This is just how this game works, unfortunately. Okay, so we're going to take a break. Oh, first of all, before we take a break, if you're listening on the podcast or if you're just watching us live on the various social medias, when this gets posted, this show gets posted to our podcast tomorrow morning. You will find the links to everything we're talking about, the report here and the other 3 seconds we have after the break. You will find the images that we show, and you will find it all on that post on our website that sends the podcast up. So we'll be back in 1 minute after this ad about our Nation program. And if you want to get involved, cjpnation.org. While you're watching the ad, type that in, and then we'll be back in 1 minute.